Bueno, visual tukunombo. Okay, come on, yeah, that's in the submission. Yeah, hello. Yeah, could you unmute yourself, please, Lawyer Wisdom? Yeah, yeah, that's good. Yeah, thank you very much. Sorry for the late start. We really, yeah, apologize for that. So I think as I said, now we've got a good number of people who have just logged in, and then others are yet to join later. So I think it's good we make a start whilst others join us later. Okay. So good evening, ladies and gentlemen. We are with Lawyer Wisdom, our own brother from Ghana, who has been kind enough to spend time enlightening us on the legal dimensions or the changes or the new legal issues with regards to immigration and then our general life in the UK. So this is part 2. We had him a few months ago, and he's been kind enough to answer our call again when we knocked on his door. So we all just prepared to ask all the questions that we have that are bothering our minds with regards to immigration in this country. I'm also available in case anyone is not able to ask a question. You could always draw my attention, and then I will ask the question on your behalf, and then inshallah we shall all stand to gain in this live session. Just to remind you all also, we are transmitting live on YouTube, SARKI TV, via YouTube. So this is going live across the world. Thank you. So in order not to take much time, I introduce audience to our speaker for the day, Lawyer Wisdom. Please, over to you.
Right, thank you very much, my brother.
It's Ibrahim.
Ibrahim, okay, yeah, all right. Yeah. Nice to meet you again. And yeah, nice to meet you. All my countrymen and women on board on Zoom, I just say good evening to you all. And we thank God for another day. It is grace and mercies that we are alive.
That's it.
Yes, and it's not by our good works or for any special reason. It's just by His special mercies and grace.
That's it.
Amen. Right. Thank you. Today, the last time we spoke about a wide range of topics, but today I want to narrow down to what I've been asked to talk on. That is the EU settlement scheme. And then also I will speak on the financial and then the maintenance requirements, and then who needs to meet those requirements. So firstly, the EU settlement scheme. Now, the EU settlement scheme is a derivation out of the EU regulations, which was actually also as a derivative out of the directives, the EU Directive 2004/38, which was the law that governed the whole of the EU, all the countries within the EU. And then once the laws were made, that they had to be transposed into the local, that every country had to transpose into its own laws. But whatever is transposed shouldn't be different from whatever the directive says. So the UK transposed it into the 2006 regulations. And then after 10 years, there were changes, so it became the 2016 regulations. So that is what governed all EU nationals and their family members in the UK. So anybody who married an EU national or was a family member of an EU national, a child, a father, a mother, brother, sister, they were all governed by the regulations 2016. And then we voted in a referendum, and the UK decided to leave the EU. On that basis, what happened then was that the UK came to an agreement, transitional arrangement with the EU. The EU nationals that are in the UK, you cannot just tell them all to pack their bags and go back to their country.
The lawyer is talking.
Sorry.
The link, you go there.
Yeah, go on. Sorry about that.
Right, that's okay. So you could not tell EU nationals and their family members to just pack their bags and leave the country. That wouldn't happen. And therefore, there was a transitional arrangement and an agreement that all EU nationals and the laws that govern the EU nationals should be changed into the UK law. And that is where we came out with something called Appendix EU. Appendix is that it is an attachment to the law itself. It's an appendix. So the law itself is the immigration rules of 1971. But the appendix is an attachment under the EU law to the immigration rule. That is why we call it Appendix EU of the immigration rules. So originally, it is not part of the immigration rules. It is now only an attachment to the immigration rules. Now, what it says is this: all EU nationals, their family members, can still benefit under the Appendix EU. However, some groups of people that are not family members of the EU national have been cut off. Example, brothers, sisters, uncles, aunties, all those people have been removed. They are extended family members. Because the UK doesn't want too many people in the country, they have found a way to cut off the extended family members of EU nationals. Originally, can you still hear me?
We can hear you. We can hear you clearly.
Okay, all right. Originally, extended family members, their right is not automatic. Family members had an automatic right, but extended family members never had automatic right. And so when it came to them bringing the law under the Appendix EU, they cut off the extended family members because they were never automatically allowed to be in the UK anyway. The Home Office had to assess to see if you were a person that was eligible to be allowed to be in the UK. So they have been cut off. So therefore, what the Home Office has done is all family members should now register. We call it EU Settlement Scheme. If you have been in the UK for less than 5 years, you apply for the pre-settled status. Pre-settled status. And pre only means before you settle. But if the EU national has been in the UK for more than 5 years or 5 years or more, then they apply for the settled status. Now, the pre-settled status is also called limited leave to remain, which is valid for 5 years. And the settled status is the indefinite leave to remain. That means you can remain in this country for as long as you wish to be in this country. So that is the basic difference between the settled status and the pre-settled status of under the EU settlement scheme. Now, what is required to be done is EU nationals must register, their family members must register, because if you do not register, the period was up to the 30th of December 2020. And then there is a 6 months grace period up to the 30th of June this year. Now, if you do not register, if you do not get your settled status or the pre-settled status, you could be deemed as an overstayer. So even if you had the 5 years residence card, the old style, which was put in your passport, or you had the residence card, which was put on a card for you, or you are an EU national and you had the registration certificate, people call it the blue card, or the permanent residence card. If you do not register to get your settled status, you will become an overstayer in this country. Even though you have it, you have the EU passport, you have the permanent residence card, or the registration certificate, or the residence card, if you do not register for the settled status or the pre-settled status, you have these things, but still you'll be regarded as somebody who has overstayed in the country. The problem that will arise is your employer will ask you to go and sit home. because you haven't met the requirements of the rules. And the employer doesn't want to be charged £20,000, so they would ask you to go and stay home. You would have difficulties accessing other social facilities in the country. If you are in a public house and if you're in the council flat, they can ask you to leave because you don't qualify anymore. And if the person is a student and they don't have the proof that they've registered, they could forfeit their scholarships or bursary because you do not fall and you don't satisfy the requirements. So the repercussions are very onerous. And so it is so simple to just register the settled status. You can go online within 30 minutes to an hour, you are done. You could do it yourself. You don't need a lawyer to do it for you. So if you know somebody who hasn't done it yet, please tell them. You could even do it on your own phone. If you have an Android or an iPhone, you could use the phone. You download the app and use the phone to do it. You do not pay anything. It is free of charge. It is free of charge. So I don't understand why anybody would not take advantage of it and wait until 30th June, and then they become an overstayer, and then all the problems that arise with it. Even if you are living in an accommodation, the landlord can ask you to produce the evidence. If you do not produce it, they can ask you to leave because you are an overstayer. You become like somebody who came to this country without a visa or have no leave. So it is a very serious thing that is I'm talking about. But it sounds light, but it is serious because the implications can be very grave if you do not do what you're supposed to do. So my advice is, please register. If you know somebody who is supposed to register an EU national and they haven't registered, please advise them to register. They have absolutely everything to gain and nothing to lose. So that is with the pre-settled and the settled status. I want to look at another angle with the EU settlement scheme as well. The question is, if you have a child, you're an EU national, we've left the EU, UK has left the EU, can you still bring your children? The answer is yes. Relationships that were existing before we left the EU, you can still apply for them to come, even after the 6th of June. Even after the 6th of June, you could apply for your children that were always your kids before the 6th of June, before the 31st of December, and then the 6th of June, you can always apply for them. Now, when they get here, then of course, once they get a 6 months EU family permit to come, then of course, you apply for the settled status for them. Children who are below 21 years old will be given indefinite leave to enter. And when they come, they'll be given indefinite leave to remain. Indefinite leave to remain once they enter with the 6 months EU settlement and family permit. Children who are above 21 years will be given 6 months to enter, and when they arrive, they will be given the 5 years limited leave to remain under the settlement scheme. And once that is done, then they have the right to be in the UK, to go to school, to use the NHS, to do whatever the law allows them to do. So that is what it is. If somebody married after the 31st of December, then of course, remember that the marriage is after we left the EU, and therefore they will be treated under the UK law, not under the EU law. But if the person married before the 31st of December 2020, they will be treated under the EU law, not under the UK law. The requirements are totally different. So let me say, two of us, you and I, my brother, you marry on the 30th of December 2020, and I marry on the 1st of January 2021. You will be treated under the EU law. You can bring your wife, your children, your grandchildren, and all of them. I married on the 1st of January 2020. I cannot bring my children just so easily because I will now be treated under the UK law. I have to meet all the requirements under the UK law before my children, my wife, and other family members can come. So the simple advice is this. If somebody wants to bring their wife, a relationship that has existed, a ceremony that had taken place before the 30th of June, sorry, before the 31st of December, that person can go ahead and apply for them under the EU law. Remember that in our country, Ghana, before you marry a woman, you have to go and see the family members first. You perform the ceremonies first, and then you later go and do the registration. So if I come and tell you that the ceremony was done on the 30th of November, that is the date of the marriage, and that is the date that would appear on the marriage certificate. It means that I married before the 30th, the 31st of December, and therefore my application should come under the EU law, not under the UK law. But whilst doing the registration, if they make a mistake and put the date of the marriage as the 1st of January 2021, then automatically they've moved me from under the EU law to the UK law. So that is the dynamics. So EU settlement scheme, EU family permit under the EU settlement scheme, it's all there in the air. I think we have to utilize it now, because after June, a lot of things are going to change, and it's going to be so difficult to make some changes or to bring other family members. So I would advise that if there is anybody on this platform, or there is anybody listening, or you know anybody who hasn't registered, I would advise that they should register, and then they can bring their family members without any difficulties at all. Should I go to the next topic and then we finish then?
Probably you just continue to the next topic. Thereafter,
All
we'll
right.
have the question and answer session.
Thank you. Thank you. So I want to also look at the financial requirements and then the maintenance requirement. Now, when you go to the immigration rules again, you look at Appendix FM Section 1.7, Appendix FM Section 1.7. That is where it talks about the financial requirements. Now, the financial requirement is for a certain group of people and not for all groups of people. So I'll use myself again as an example. If I decide to marry, and the whole of the UK, I haven't found any woman, and I decide to marry from Ghana and bring her here, or there's this lady here, the whole of UK, she hasn't found any man here, she wants to go and marry from Ghana and bring, then you have to meet the requirements under the financial requirements, which is under Appendix FM Section 1.7. Who must meet the requirements? If you are a British citizen and you marry from outside, you have to meet the requirement, or your spouse has to meet the requirement. British citizens, anybody who has indefinite leave to remain, anybody who is here as a refugee, or anybody who is here under the humanitarian protection. And this time they've added 1.3, EU nationals who have been given the indefinite leave to remain in the UK under the EU settlement scheme, GEN 1.3, they also, if they marry after the 31st of December, they also have to meet the financial requirements. So I'll go over the list again. British citizens, spouses, spouses of a person or a spouse of a person who has indefinite leave to remain, a spouse of a person who is here on humanitarian protection, a spouse of a person who is here on asylum leave, and a spouse of a person who is an EU national who has been given indefinite leave to remain and is marrying or has married after the 31st of December 2020, would have to meet the financial requirement. And also dependent children. So when I go, or if I go and marry, and then I'm bringing my wife, or my sister marries, she's bringing the husband, and I want my wife and my stepchild or my child to come with her, I have to make sure my wife and my child all meet the requirements under the financial requirements of the Appendix FM of the immigration rules. Now, what do you have to show? What do you have to show? You have to show the amount is called £18,600. £18,600. That, so remember, I am talking about the financial requirement, not maintenance. We have F and we have M. The F stands for the financial, the M stands for the maintenance. Right now, I am talking about the financial. Now, you have to show you meet £18,600 if it is only your wife or your husband that is coming. If it is only your wife or your husband that is coming, only your spouse, it is 18,600. If you have one child also coming with your partner, then you have to show additional £3,800. So that takes it to £22,400 a year. And let me mention here, it is gross, not net. It is gross, the amount you are paid before tax, not the net. It is the one that you are paid before they take out all the deductions. It is not the one you are taking home. So it is gross, not the tax. Then we also look at if there are 2 children coming with my wife, so I need 18,600 plus 3,800 plus 2,400. It means that every additional child, apart from the first one, must meet 24, 24, 24, 24. So if I am bringing my wife and 2 children, then the total is 18,600 plus 3,800 plus 2,400. And that gives me a total of £24,800 a year. Now, again, it is gross, not the net. So the more dependents you have coming, the more you have to meet. So the strategy is simple. If you do not meet or you cannot meet all of this, let your partner come first. Let your wife come first, or let your husband come first. Then once your partner or your spouse comes, the 2 of you will be working, then you can put the 2 together, then you meet the threshold for the children to also join you. Otherwise, they will never come. If you are unable to meet the threshold, they will never come. So let your wife come, let your husband come, the 2 of you work. You are earning 12,000, you are earning maybe 15,000, she is earning another 7,000 or 8,000. You add the 2 to it, the 2 of you meet the requirement, then the children can join you without any difficulties at all. That is a strategy that you can use, provided you have somebody, a family member in Ghana you can leave the children with. That is normally the problem. Sometimes we don't have family members you can leave the children with comfortably without getting worried about their safety and all those things. So that is usually the problem. But if you have, then that should not be a problem at all. So if you have one wife and 3 children coming, then you are looking at 27,200 gross. So that is what it has to be. It is not the amount of money that is sitting in your account that we are looking at. No. So somebody can say, oh yes, I earned that money, but I don't have any money in my account. My balance is 0. We don't care about your balance. Even if you are in negative, we don't care. What we care about is, does that money show on your P60? Does that money show in your bank account? Does the money show on your pay slips? These are the 3 things. The P60 has to show how much you earn. The bank account has to show the money is reflecting in your account. The pay slip has to show that the money has been stated on your pay slips. And once these 3 things, together with the letter from your employer, come together, then you meet the financial requirement. Even if you are in arrears, even if you are in negative, even if you are on, what do you call it, overdrafts, it doesn't matter. It does not matter. It is not what the balance we are looking at. So nobody should worry because they don't have 16,000 sitting in the account or so. That is not a problem at all. Now, the question then is, what if somebody cannot meet this requirement? If the person is only earning, let's say, £15,000. Now, if the person is earning only £15,000, it means that you are short by 3,800, by 3,600. So, if we all have pen or paper, we can do a bit of calculation. Now, assuming you are supposed to meet the 18,600, but all that you get is £15,000. It means you are short by 3,600. Now, what you have to do is this. You have to multiply that 3,600 by 2.5. 2.5 because they give you 2.5 years to come, or they give your wife 2.5 years to come. So you multiply the 3,600 by 2.5. And then you add the total to the 18,600, and you must have a savings of £16,000 sitting in your account for 6 months without touching it. So I'll go over that again. If you are short of the 18,600, even by 1p, or let's say by £1, let me make it simple. If you are short by 18,600 by £1, you have to multiply the £1 by 2.5. That would be £2.50. £2.50, you add it to the 18,000, the difference, plus a savings of £16,000. So once you are short by even 1p, the £16,000 is automatic. You must have it. If you are short by even 1p, the £16,000 automatically kicks in. So I advise people, if you are short and you don't have the 16,000, just take your time, get a second job, work 6 months, add it to what you already have, and you meet the 18,600, your wife comes, no problem. Whether you have savings or not, you don't have any difficulties at all. Unless you have £16,000 sitting in your account, then when we finish, I'll take your telephone number and I'll talk to you so that maybe you can pass more to me. Yes. So it's not easy to save money in this country because it's coming and it's going, it's coming and it's going. So we use other strategies to meet the requirement rather than the £16,000 savings. And that money has to be in your account for 6 months. You don't touch it. If you come down by even 1p, you do not meet the requirement. Don't refuse the application. Then the other thing is, I've looked at this 16,000. Assuming the person is not working at all. If the person is not working at all, then the calculation is maybe you want to rely on your savings. If you want to rely on your savings, then it's going to be 18,600 times 2.5. That will give you 46,500 plus 16,000. That is 62,500 pounds sitting in your account as your savings for 6 months before your partner can join you. So you are not working at all. If you are not working at all, the 18,600, you multiply it by 2.5. And then that gives you 46,500. Plus, remember, the 16,000 is automatic as long as you don't meet the 18,600 from the scratch. So if you add it to it, you need 62,500 pounds sitting in your account for 6 months before you can apply for your spouse to join you in the UK. In fact, that will give you a headache. If you are not very careful, the marriage may go on the rocks. So let's use the other strategies, and I'm sure that will help us out. There are some people who do not have to meet the 18,600 requirement. There are people who do not have to meet it. Example, if there is somebody in the UK who has a child, assume I'm here with a child, and my child is British, and maybe my wife, the same child is my wife's child, and the child is British, you do not add that 3,800. The children who are British or have indefinite, you do not add theirs to the 18,600. If the child is British, or my wife has my child, and the child is in Ghana with my wife, and my child is British citizen, as long as my child is British citizen, you do not have to add the 3,800 to the 18,600. In that case, you are only looking at the 18,600, not plus the 3,800. So if I have 3 children, they are all in Ghana, They are all British citizens, and I want to bring them with their mother. All I have to show is the 18,600 because the children are British citizens. I don't have to meet the additional 3,800, 2,400, 2,400. So that is also an information I think you should have. Then the next thing is, I was talking about people who do not have to meet the financial requirement. There are some categories of people who do not have to meet the financial requirement, but they have to meet the maintenance requirement. Maintenance requirement. Now, if there is somebody in the UK who is receiving PIP, I think we all know, or most of us know what is PIP. Personal Independence Payment is a payment they give to people who are on some sort of disability. Yes, so if the person is receiving PIP, Personal Independence Payment, you do not have to meet the 18,600, no. If the person is receiving carers allowance, so the person is not well, the council is supporting the person, the Departments of Works and Pension is supporting the person, they're giving the person carers allowance, they do not have to meet the 18,600. They have to meet the maintenance requirement. I'll come to that. If the person is receiving police injury pension, assuming there's a lady here who is receiving, or there's a gentleman who is receiving the police injuries pension, the person is a policeman, got injured and is receiving payment for that, they do not have to meet the 18,600. Or industrial injury allowance, person went to work, got injured at work, and the Departments of Works and Pensions have assessed based on the medical reports, and they are paying that person industrial injury allowance. That person does not have to meet the 18,600. No, you don't have to meet that. Or the person is having disability living allowance. If the person has disability living allowance paid by the Departments of Works and Pensions, you do not have to meet the 18,600. All you have to meet is the maintenance requirement. I'll go to the maintenance requirement. Before I do that, what documents do you have to use to show that you meet the financial requirement? One, you need your bank statement, 6 months bank statement, 6 months bank statement of a bank that is recognized in the UK. I know sometimes we'll be using this online bank. We call it Monzo. Monzo is not one of those ones that has been accepted. So please don't use the Monzo. Use all other banks, Halifax, NatWest, Santander, Barclays, Royal Bank of Scotland, and all the other banks, they are acceptable. You need 6 months bank statement, not 6 bank statements. I'm not talking about 6 bank statements. I'm saying 6 months bank statement. There's a difference between 6 bank statements and 6 months bank statement. I'll give you an example. There's this client of mine, she was paid twice in a month, at the beginning of the month for the last month, and then at the end of the month for the same for the next month. Now, it was 6 month statements, what do you call it, statements or pay slips, but it was for just 5 months pay. So she forgot to check the specific months. So you check every month. This pay slip is for this month. This pay slip is for this month. You can use highlighter and then you highlight all the dates. This is for January, February, March, April, May, June. And then you check that the amount on the bank, on the pay slip reflects in the bank statement. Because the Home Office, they are smart. The caseworkers are smart. They will compare the amounts on the pay slip to the amounts on the bank statement and see if it matches. I have seen a case where the gross was less than the net. Does it happen? I have seen a case where the gross was less than the net because it was done a quine chain somewhere. it wasn't properly done. So these people, they know these things. So they want to be sure that the correct amount reflects in the account. Otherwise, the application will be refused and you will have a lot of difficulties. So 6 months bank statements, 6 months pay slips, and then you need a letter from the employer. The letter from the employer has to state 4 things. When you started the job, your annual salary, when you started receiving the level of income, and whether it is a full-time, permanent, contract, or agency. It has to state these 4 things in that letter. It can just be 1-line letter, 1-line sentence. I can confirm Mr. So-and-so is employed with us. He has been employed since this date. His annual salary is this amount. He started receiving this amount on the 5th of April, and it is a full-time job. It's just 1 line, but it contains all the information. So that is what it is. 6 months pay slips, 6 months bank statements, letter from employer, P60 has to also show. These 4 things are essential. They are mandatory. If you don't add it, automatic refusal. They will not even go on to look at the application. They'll refuse it automatically. This is what we call the specified evidence. It is specified evidence. If you do not produce it, automatically application will be refused. It's specified, so if you don't produce it, there's even no ifs, no buts, no negotiation, or the case worker can say, oh, I want to write to you to send it. It's specified. There are sometimes they have discretion, but there are some cases they don't have discretion. If you don't send it straight away, they refuse it. They take your money. It's a lot of money, over £3,000. They will take your money. The only thing they'll refund to you is possibly the IHS. Even that, they take a lot out of it and they give you the rest. If you have money to throw away, please don't throw it anywhere. Throw it on me. I know what to do. We know what to do with that. So please, 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 that is it. So now let me go to the maintenance. I've talked about the maintenance. Now the maintenance requirement is for people who do not have to meet the financial requirement. If you do not have to meet the financial requirement, then you have to meet the maintenance requirement. Now, there is a case. The case is called the case of UVOVO. U-V-O-V-O. U-V-O-V-O. The case of UVOVO. Anybody can Google it. You can go on Google and just enter tribunal decision, the case of UVOVO. U for umbrella, V for Victor, O for Oscar, V for Victor, O for Oscar. The case of UVOVO. Now that case is a start case. Now what it says is that in the UK, they don't want people to live below the poverty line. They don't want anybody to be in poverty in the UK. So that case says there is a threshold that anybody who is living in the UK below that amount is living below the poverty line. And therefore, the government has to support them. That is why we call the income support level, the income support level, and it changes every year. So if your income is low, the government has to support you. If your income is low, the government has to support you. That is why some of our brothers and sisters, our mothers who are working, if you are taking benefit, they tell you if you work beyond a certain number of hours, they'll reduce your benefit. So you have to be at the threshold or below that amount before the government can support you. And that is what we call the income support. Remember, it is income and then support. So your income and then they support you. And that is the level. So if your income is too high, then they cannot support you. If you are at the threshold as specified in the case of UVOVO, then the government will support you. So if you do not have to meet the maintenance, maybe you are receiving carer's allowance, personal independence payment, police injury, industrial injury, or disability living allowance, and you cannot or you should not meet the financial requirement, then you have to meet the maintenance requirement. And the maintenance requirement is simple. You have to, lone parent. So if it is just you here, you want to bring your spouse from Ghana, lone parent a week. is you have to have £74.35p a week. Let me see what that means. £74.35p a week. If you multiply it by 4 weeks in a month, you need £297.40p for a lone parent, for a single parent. If you're a single parent and you want to marry from outside and you are receiving PIP or any of the disability living allowance, all you have to show is that you can provide £297.40p a week. Now, if you, it's £74.35p a week times 4 weeks is £297.40p, 297.40. Now, if you have children, then you also have to add one child is 68p 27, 68 pounds 27p, 68.27. That is for a child. 68.27 for a child times 4 weeks. So for one child, it is 273 pounds and 80p, 273.80. I think my math is right. 68.27 times 4, that is, yes, 273.08p for the month. So you have to add your money, 297.40, to the child's own, which is 273.8, plus your rent and your council tax. Your rent plus your council tax plus this amount. Now, assuming there is no child involved, assuming the person is receiving PIP, carer's allowance, or disability living allowance, or only one, you need only one of these, you don't need all the 3 allowances. Assuming you are receiving only one, which is disability living allowance, and you want to marry from outside, you want to bring your spouse here, all you need is £297 a month plus your rent plus your council tax. That is all you need to show that your spouse can join you. But if that is if you're a single person, but if your spouse is coming, then the figure changes from 74 to £116.80p a week. That is a couple, because your husband will also come or your wife will also come and also live. And so it changes from the 74.35 to 116.8p, 116.80p a week. So when you do that calculation, that brings you in the coverage of how much you need for your spouse to join you here in the UK. You do not have to show 18,600. No, you do not have to show additional 3,800. No, all you need to show is £74.35p. For a couple, is 116.80 times 4 weeks plus your rent plus your council tax. So the amounts that you receive from the Departments of Works and Pensions, if it covers the total, then you are good to go. So if the total comes up to maybe £1,000, so let's say you earn, your rent is, let me just use an example, your rent is £400, and then your council tax is £100, that is 500. So you have to add the 500 to the £297. So you need just under £1,000 for your spouse to join you here. Whereas a person who has to meet the financial requirement has to show 18,600. You are only showing less than £1,000 a month for your partner to join you here in the UK. So this is the broad difference between the financial requirement and then the maintenance requirement. Visitors, if you are inviting somebody, you do not have to meet the financial requirement. You do not have to meet the maintenance requirement. there is no financial threshold for visitors. No, there is no financial threshold for visitors. However, you have to show that when the person comes, you can look after them without going to the council to say, oh, I have a visitor, and my money is short, so can you top it up for me to look after my visitor? That would not happen. So therefore, if you are going to pay for the person's visit and their stay and everything, then you have to ask yourself, how much money do I have in my account? How much is the travel cost? How much is the plane fare? How long is the person spending here? You do your calculation. This is what I tell my clients. If you want your brother, your sister, or cousin to visit you, and you are going to pay their plane fare and look after them whilst they come here, you look at your account, you have £1,200. Meanwhile, the plane fare is around £600. How much is left? £600. Now, when they are coming to spend, let's say, 4 weeks or a month. How much are you going to use to support them? How are you going to pay your rent? How you pay your council tax? So automatically, although there is no fixed amount, automatically you have ruled yourself out of the game. So in that case, the more you have in your account in savings, the better the chances you have in meeting the requirements when it comes to looking after the person or paying their fare and everything. If the person is paying their own plane fare, that is fine. But you still also have to show that when they come by all means, I mean, no confuse. So you take them out, you know, things like that. So you can show your bank statement, your pay slip in addition. So this is it broadly. I'm sure there are some questions I'm more than happy to respond to.
Yeah, thank you very much. Thank you so much for these detailed explanations. I know you've been very thorough, very detailed, but I think we still have some kind of, should I say, tailor-made questions? Because
Sure.
So to start with, my first question is, if someone is married to an EEA citizen prior to 31st December 2020, and then I think the relationship is a bit wobbly, but the woman has decided, can the woman apply for the pre-settlement even if the man has not done his pre-settlement application?
Yes, it is possible.
Okay.
As long as the parties are not divorced.
Yeah, okay.
There is a case of Aishetu Diata.
Yeah.
It's an European case.
Okay.
In that case, the EU national took the wife to another EU country.
Okay.
And the relationship broke down. Yeah. And then the man decided to go back to his country.
Yeah.
And the woman was left stranded.
Okay.
Now the case went to court, and the court said, no, you cannot just leave the woman like that. The fact that you've taken some, if you do that, it gives the man advantage, or it gives the partners advantage. They just go down the other party because there's a misunderstanding, and then they go away, and then the woman is stranded. Yeah. So the court says separation, even if there is separation, for even 1 year, 2 years, 10 years, 20 years, as long as you are not divorced, you are still married. Okay. And therefore, the other party can still apply based on the EU national.
Okay.
The problem here is this. Normally what happens is when you apply, because you do not have the EU national's passport details and stuff, the Home Office may come asking for whether the EU national has applied for the pre-settled status. Okay. In that case, if you don't know, you take no, and then you move on. They will come back to you and ask for you to provide his passport, to provide his registration certificate details or the settlement scheme details. And then you respond back to them and say, under the case of Aisha to Diata, the relationship is broken. We are living apart. I don't know his whereabouts. I know he's in the UK. However, you, the Home Office, you have the power to contact the HMRC under paragraph 40 of the Borders Act 2007 and ascertain that he's in the UK and working. Because the Home Office has power to contact all government institutions to derive or to get information in making an immigration decision. And that power comes under paragraph 40 of the Borders Act 2007. So you can apply. They may come asking for questions, and then you respond to them that way, and then you should be given the settlement scheme. Yeah.
Okay. Oh, that's good. Thanks very much.
So
thank you so much for that detailed question. Please, if anyone has a question, just draw my attention. Tajuddin. Tajuddin, can you unmute yourself, please, and speak up?
Hello.
Hello?
Yeah, can you hear me?
Yeah, we can hear you.
Yeah, good evening.
Good evening.
To everyone. Yeah, my question is, when you apply for, what do you call it, settled status or pre-settled status, either one of them. So what happened when you are granted permission to limited or indefinite, and then yet you have not applied for the card? So what is your status, or is it like, what has the card got to do with your situation? I mean, and then I have two questions. And the second question is, someone married to AU national, you know, and along the line, I think, what do you call it? I think she was given 5 years, and it was over now. And then the person can't find a partner anymore, and she doesn't have the detail of the partner, which means the relationship is broken. So what is the situation of that person? Can that person apply for settled status or pre-settled status? That's my question here.
thank you. I'll take the second one first.
Okay.
I think that relates to the one I just answered before you came in. Now, if the relationship is broken, the question is, are they divorced or they are still married?
They're still married, but like when they married, I think when they married, and the person couldn't find the wife or husband since from day one up to like maybe after 5 years, and she couldn't find the person. So she doesn't know, or he doesn't know her whereabouts.
Hey, so if you the day you marry your wife, or the woman married the husband, you can't find. This is why there is this is like getting married to a ghost too.
Yeah, but you know, people want to sort out things, so they try and everything. Especially those from the beginning, those people used to.
Okay, I think I get the question. Yes.
Okay, thank you.
All right. Now the difficulty with this is, if it's difficult for you to find your spouse, you do not know whether your spouse is in the UK or has been in the UK over all these 5 years and has been working. If
okay, sorry, sir. I want to. It's no more in the UK, and then he left UK. It's in another European country. Yeah.
Okay. Then that becomes difficult. For all you know, he or she has not really even registered worked here for any period of time, because the pre-settled or the settled status, remember, it is tied to the EU national. So the EU national is the tree. Like I always say, and you are the branch on the tree. So if the tree left the UK, then technically the branch has been hanging all this while without any basis of being in the UK. So if you make such an application, they may ask for the EU nationals' details. If you're unable to provide it, it is likely the application will be refused. However, if there was a divorce, let's look at it from this case. If there was a divorce, then you could apply on the basis of retained right of residence under the old system, which is Regulation 15.1F, with reference to Regulation 10.5 and 10.6. Now, what happens then is you have to show that the marriage lasted for 3 years before the divorce started. Number two, you have to prove with evidence that the woman has lived in the UK for at least 1 year before they left. Number three, you have to show that on the date of the divorce starting, the woman was here working up to the date of the divorce. The date you started the divorce to the date the divorce finished, the marriage finished, the woman was here working. And then you have been here from that day of the divorce onwards working. So 4 things. Marriage lasted 3 years before you started the divorce. Number 2, the woman has lived in the UK for at least 1 year within that 3 years. Number 3, she was here before you started the divorce working, and onto the date of the divorce, she was still working. And number 4, from the date the divorce finished, you have been working throughout. If you meet these 4 things, then you can apply under retained right of residence under Regulation 15F, 1F, Regulation 10.5, Regulation 10.6, which have been transposed into the Appendix EU. If you can't show these things, then I am so sorry. There's not much that can be done to salvage this situation. The second question, or the first one, is if you have applied and they have given you the settled status or the pre-settled status, we have 2 scenarios. People who do not have the card. People do not have the card. Some people have the card and then they change it to the settled status. Now, if you do not have the card, then they will issue you a card, a new card. But if you have a card, the letter, the email that was sent says, if you do not already have a biometric card, you will be sent a card within 7 to 10 working days. Listen to the clause. If you do not already have a biometric card. In that case, if you have the card, they will not send you another card. But you can apply for the card after you received the settled or the pre-settled status. Let me just show you how the card looks like. Sorry. It's a kind of new cards they are providing for. This is how the card looks like. I hope you can see.
Yeah.
Yes. This is the new card. And it has no chip at the back.
Okay.
It looks different from what it was before. The first one was looking like pink card or so.
Yeah.
But this one is changed. It's a different card now.
Okay.
So after you got the settled status or the pre-settled status, you can always apply to replace. You're applying to replace the old card that you have. But if you want to keep the old card because it is going to expire in 2025 or 2024, you can still keep the old card together with the letter, the email, and you are still good to go.
Okay. That's good. So just a follow-up question onto that. So if you have the pre-settled status, that gives you limited leave to remain. Just that lasts for 5 years, isn't it?
That's
so
for 5 years.
Yeah, so what happens thereafter?
The 5 years actually starts from the date of your marriage.
Okay.
So assuming the person married 3 years ago and was given the pre-settled status up to, we are in 2021, up to 2026.
Yeah.
You do not have to exhaust all the 5 years up to 2026.
Okay.
You count the 5 years from 3 years ago, so you have technically 2 more years to go. So once you do the 2 years on top of the 3 years, you go for your settled status, your indefinitely to remain. Yes.
Okay. What about if an EEA citizen in the country brought his spouse who has been a dependent on him? So, and from the time she arrived, she did the pre-settle application and all of that. So how long does she have to wait until she goes for further application?
Right. I'll look at it this way. Children under 21 years of the EU national and their spouse are given indefinite leave straight away.
Okay.
If the children are under 21, you apply, they should give them indefinite straight away.
Okay. Okay.
If they are above 21, they give them 5 years.
Okay.
The wife, the husband, the wife, they also have to be 5 years in the UK before they can go for indefinite.
Okay. All right. That's cool. I think that's very clear. So please, the floor is still open. We still have Lawyer Wisdom with us. If you have further questions, he's more than happy to take them. And at the end of the last session, we did send around his contact number. So I hope a lot of people have been able to make contact. And those who have followed up questions, I think this is the opportune time. Taju, you want to come back again? Yeah, unmute yourself, please.
Thank you very much for You really answered the question very well, and thank you very much. I appreciate it.
Thank
And
you.
my other question is, it has to do with maybe when you marry, when you go to your situation settled through the AU citizen, and then which maybe he or she has a pre-settled status, maybe from one of the European countries, Germany, France, you know, and then the person has a pre-settled status, and then you guys have a baby. And how does can you, apply for a British passport for the baby, or how are you going to go about it?
Yes, the British citizenship arrives, or the child gets the British citizenship when if the parent is settled. So that moves us from under the EU to the nationality law. And under the nationality law, British Nationality Act of 1981, it says if section 1.1, if any of the parent is British, the child is British automatically. Section 1.1 again says if any of the parent is settled or has indefinite leave, the child is a British automatically. And then when you go to section 1.3, it says if the child was born and the parent is not settled, hasn't got settlement or indefinite, and then later the parent gets indefinite, you have to register the child as a British citizen. In that case, the child is not automatically British. So I normally say we have automatic and we have manual. Automatic is
That's a good one.
Yes, the manual is you have to register the child as a British citizen, because at the time the child was born, the father or the mother wasn't having indefinite. So to your question, if the EU national had pre-settled status, it means they are not settled. And because they are not settled, the child cannot be British. The child will only become British after the parent becomes settled, and then you register the child under section 1.3 of the British Nationality Act of 1981.
So how do you go about the registration, please? Just a follow-up question.
Yes, registration.
If the child is not even in the country, but you want to register the child.
If the child was born in the UK, then the registration is under section 1.3. If the child was not born in the UK, then the child is not a British citizen. You have to apply to bring the child here first.
First, okay.
And then ultimately the child gets their indefinite leave to remain.
Okay.
And then when the mother is going or the father is going to apply for their British citizenship, you apply together with
the child.
The parent.
Okay.
Yes. Otherwise, we have, I just mentioned section 1.3, but there is also section 3.1. Section 3.1 is for children who are brought from outside the UK. Okay. 1.3 is for children who were born inside the UK. Okay. 1, subsection 3, inside. 3, subsection 1, from outside. So it depends. It's very technical. Yeah. And so, but the easier way to remember it is UK, number 1, 1.3. Yeah. From outside, number 3, 3.1. That's how to look at it.
All right. Thank you very much. And then if no one has a question, I've got another question to ask. Is NHS levy, because I've heard a lot of rumors in terms of part of the financial commitment that you need to meet an NHS levy, which is, I think, from 600. Others is rumored to be over 1,000. I don't know, because you talked about financial commitment earlier on. So I think
yes, that's true. There is it started, we call it the immigration health surcharge, health surcharge, or the IHS, which most of us just call it that way. What it means is any person who is bringing a family that is not a British citizen, if you're British, you're bringing a family, your family is not an EU national, and they are not coming with indefinite leave to enter, the person who is coming has to contribute to the NHS. Okay. Because when they come, they may use the NHS, the health services. Okay. And it used to be £200 a year. And then they increased it, And now, as we're speaking today, it is £1,560.
Wow.
Yes. And that increment was in October, I think 27th of October 2020. That is when they added £560 on top of it.
Per person.
Per person, in fact, per head. So more or less, they are cutting your head. So,
Wow.
yes, it's 1,560 per person. But if you are applying for your child to come to settle indefinitely to come, they don't have to pay. If the family member is an EU national, they don't have to pay. If the person is an Irish national, if you're an Irish national, you're applying for your family to come, they don't have to pay. But anybody else, if they are coming with 2.5 years to be in the UK, then they have to pay the 1,560 on top of the application fee itself, which is around £1,530. So you are looking at over £3,000
Per person.
per person. If you apply under the immigration rule.
Sorry. Who is? Hello. Sorry. Who is that?
That's okay.
Yeah,
That's
go
okay. Yes. So if you are applying under the immigration rules, then it has to be 1,530 plus 1,560 over £3,000 before the partner will come. And that is why the applications under the EU law are better, because they don't pay anything. They pay zero. They pay zero.
Okay. So with this figure, just for point of clarification, that is under visiting visa, or is when they're coming for permanency?
When they are coming to settle permanently.
Permanency. So you
Yes.
pay this money.
Yes, visit visa, they don't pay any of
Anything.
this.
Okay.
Any visa that is under 6 months, they don't pay
Anything.
Yeah.
Okay. Wow. All right. Thank you very much. I've got a hand up here, Galaxy Note 9. There's no name. Could you please unmute yourself and ask your question?
Yeah. Good evening.
Good evening, sir.
Yeah. We have a quick question regarding the EU settled status.
Right.
Yeah. I got a European EU spouse. We've been married for almost 3 years now. Yeah, but at the moment, I got my EU settled status. But I got 2 kids back home in Ghana, and I wanted to bring them, but without the participation of my spouse. I wanted to do it on my own. So is it possible if I can do it, and how much is it going to cost me?
So you are married to an EU national?
That's correct.
And
And I got 2 kids back home in Ghana.
How old are they?
Yeah. One is almost 12 and the other is almost 9.
Perfect age. Now, is your wife happy with you bringing the children?
No. No, that's why.
All right.
Yeah.
Well, is it where persuasion fails?
Force myself. Right?
In some cases, you have to. Look, you've got to do what you've got to do. But obviously, you would need the proof that you need a marriage certificate. That is one, to show the connection between you and your wife. That is one. Number 2, you will need a children's birth certificates and plus a DNA to show that they are your children. Number 3, you would need her EU registration, the unique reference number. That's 16-digit unique reference number. You would need that. Next, you would need her passport details. You would need her pay slips if she is working. Or if she's a self-employed person, you would need evidence of registration with the HMRC. So although it's not straightforward, I would say once you can secure these documents, then let me use the word persuade her, and then you can use the documents to bring the children the children will come without any problems at all. Because if you don't bring them now, and ultimately you end up getting your indefinite, and you want to bring the children by yourself, if you are not still married to her, you will come under the UK law, and that is so difficult, so difficult to bring the children under the UK law, the immigration rules. You have to show something we call sole responsibility, and that is a very, very, very tough animal to handle. So if your wife is being difficult, please speak to her. Somebody once told me his wife likes money, and I say, yes, my mother too. So if your wife likes money,
let it be.
Yeah, I know what you are saying, but sometimes you, like as you say, you got to do what you got to do. Probably, yes. I was thinking just after June, I think that's the end of the.
No. You can still bring the kids because they have been there long before the exit. So you can still bring families that are existing before the 31st. You can still apply for them. But I would always advise anybody, if you can do it now, why wait until after June? That's my point. But if it's not possible before then, and I hope the law doesn't change, then you can still bring them after June.
Oh, thank you.
Oh,
You're welcome.
Thanks so much.
So my mother likes money too, okay? So.
Yeah, thank you very much, Lawyer Wisdom. I think I've got a follow-up question. That can an EEA national living and working in the UK do the pre-settle application whilst his passport and card are still under renewal without those documents with him or her?
The EU settlement scheme, yes. What happens is if you use the passport itself and you use your phone, you use the app, you don't send the passport, you just scan it back and front, and you don't send the passport to them or the card to them.
No, the passport and the card, I think they are expired and then pending.
Oh no, it has
renewal.
to be valid. It has to be valid.
Okay.
Yes, if it's expired, you can't use it.
Okay, all right. Thank you very much. Please ask your questions. We still have about maybe 5 more minutes to go. There's a question. How much it will cost? Okay, that question has been answered. So I think the questions are not forthcoming, so we could start wrapping up. Maybe as we go along, people may recall their questions. There's a hand up. iPad guest, could you please ask your question? That might be our last question.
Good evening, sir.
Good evening.
Please, just a quick question here. Please, do EU nationals need to take a life in UK test before they apply for indefinite? Yes, sir.
No life in the UK test for indefinite, but life in the UK test and English language test B1 for British citizenship.
Okay.
So if you're going for the indefinite, no life in the UK test, no B1 test. But if they want to go for the British citizenship, yes, they have to do the life in the UK test and they have to do the English language test level B1, unless they have a first degree, then they don't have to do the B1. But for the life in the UK, even if you're a professor of English, you still have to do it.
Chairman, not a question.
Okay, thank you.
Okay, ask your question, Imran.
Good evening, sir.
Good evening, sir.
Please, if somebody is adopted from Ghana to here, but now the person wants to take a passport, what he need before he get the passport, please?
Which passport? You mean British passport?
Yes, please.
Which adoption? Are you talking about a EU adoption or
No,
a child?
No, the British.
How old is the child, the person?
The person is 24.
When was the person adopted?
Almost 7 years now.
So if the person is 24 now, almost 7 years, it means they were around how many years? 17 years old.
The adoption at 17. Okay.
Well, yes, adoption it covers below 18.
Yeah.
Yeah.
So what did they come to the UK with? Indefinite?
Yes.
If they came with indefinite and they've been here for 5 years, they should write the life in the UK test and write the English language test level B1. They apply for the British citizenship. Yes.
Okay. So they don't need anything from the person who adopted them.
No. They are adults now, so they don't. They'll just ask you for your parents' names. The names will come. The father's name, mother's name, details will come on the form, and that's it. You get a 2 referees to sign for you, and you proceed with the application.
Oh, okay. Thank you very much.
You're welcome, sir.
Yeah, thank you very much. I would have loved us to wrap up, but there's a hand. I think we take the last question, please, with your permission.
No problem, sir.
Galaxy Note 9.
Yeah, hello.
Yeah, hello.
Hello.
Yes, hello, we're here.
My question is, if you have a BRP under EU family member, and it's gonna expire 2022, but prior to that, you have your EU settled status. But when it expired 2022, do you still need to apply for the indefinite, or you don't need it because you already have the settled status?
Well, if you already have the settled status under the Appendix EU settlement scheme, and by the time it expires, you qualify for the British citizenship, I would say go for the British citizenship, unless you want to go and do politics in Ghana. You don't want a British citizenship. But if that is not the case, then when it expires and you're not eligible for the British citizenship, it's not, all you have to do is to complete another form for them to reinstate your card for you, which is the indefinite leave to remain. We call it NTL, no time limit. The form is called Form NTL, no time limit.
Okay, the reason why I was asking, I spoke to a friend of mine regarding the same situation, and he told me, because I've overstayed before, I need to complete the 10 years before I can get the British citizenship. That's
correct. That is absolutely correct. And it's covered under something we call the good character requirement. Good character requirement. Maybe the next time we meet, I will look at the 20 years, 10 years, and also look at another thing called the good character requirement. But you give me the topic and I'll treat it. Now,
with my BRP, with the BRP, which is prior to expire 2022, because I don't need, if it's expired 2022, which is the card is invalid anymore. Only what I have is the settled status. So do I need to apply for a different card?
Yes, please apply for a different card, because if you need to travel, you can't travel with the expired card. Although you have the settled status, you still need a card plus your passport to travel. So yes, please apply for the new card, and that allows you to carry on working. But I can even advise you right now that if you don't mind, just apply for the new card. The new card they are issued, I showed one, and that they'll give you that card and they'll write on it settlement scheme. That is EU settlement scheme, which is indefinite. In that case, you don't have to. And that, if it is indefinite, it's indefinite. So you don't have any problems.
Okay, so I can apply it now without.
You can apply, yes, you can apply now.
All right. Okay, thank you.
You're welcome.
Thank you very much, Lawyer Wisdom. Thank you so much. On behalf of ZUMUNTAH Association, on behalf of all the listeners today, we want to say a big thank you for your time and effort.
Pleasure, my pleasure.
It's much appreciated. And then I hope we cross paths again. We still have your details, and then we continue to advertise and encourage people to seek legal advice rather than roadside advice, which are always easily able to mislead people. So once again, thank you very much. Thank you so much.
Thank you very much too. Thank you very much too. I just wanted to finish with the good character requirement my brother mentioned.
Okay.
Now, the good character requirement is a whole booklet on its own. Now, 10 years, they want you to be here for 10 years lawfully before you can apply for British citizenship. Because when you were coming to the country, they ask you, when you come, will you go back? You said, yes. All of us say we'll go back. I said, I'll go back. 3 months, I'll go back, and I'm here now.
That's it.
So they tell you your character is not good because when you came, you say you go back here. So stay here for 10 years lawfully before we give you the British citizenship.
Oh my
So,
goodness.
but yes, but it has a whole lot of other factors. So I'm sure one of the meetings I will look at that, what we should do, what we shouldn't do when we want to get our British citizenship. And possibly, maybe one day I will discuss the advantages of dual nationality and the other one. If you are here, you have Ghana citizenship, you British citizenship, what are the advantages and disadvantages? So
Okay.
as we go along, we have more topics to speak
To
on.
cover. Okay.
Yeah, thank you so much. I'm grateful to all of you for making time and then for listening. I'm grateful. Wisemart Solicitors, I think you have the details, so you
Yes,
can just
we have it. Yeah.
Thank you and God
All right.
bless. I'm
Thanks
grateful.
so much. Thanks so much. We really
Thanks.
appreciate your time. Thanks.
Bye.
Bye. Bye. So thank you, everyone. Thank you for your time. Thanks for the questions. I hope he dealt with all the questions that have been asked. And Muna the details and Shikuma, Serkina the details and Shina the details and so when in the future Kebidam Temoko, he's still available to help. Office in Suna Dostin in London. So that was Lawyer Wisdom from Wisemart Solicitors.
Chairman, not for the Jama every month, every last Sunday of the month, data